Dear friends of the Observatory for the Protection of Taxpayers' Rights, today Philip Baker and I are here with you to share with you some views about the developments concerning the protection of taxpayers' rights in 2020. We hope that you will enjoy our video clip. 2020 has been a particularly difficult year for the mankind, and we all know the problems of COVID-19. And we are all aware of the difficulties that have also arisen in respect of the protection of taxpayers' rights. I think it's important from this perspective to take into account that the protection of taxpayers' rights must be secured at all times, also in the moment in which there has been, perhaps for the first time, a global force majeure event, which has prevented taxpayers from complying with tax obligations. However, I think it's also quite important that we take into account that there is an obligation for all taxpayers to contribute to funding the public revenue. And from this perspective, it could be potentially important also to see that the reported developments from around the world have indicated various degrees of tolerance for situations of incompliance. And it is important for us to show that the ones connected with tax procedures are more closely related to cases of force majeure. So when, for instance, tax authorities have requested the delivery of some documents, and at the end of the day, there has been at one moment the lockdown, then of course, this is a clear-cut case of force majeure, and we have seen evidence reported from throughout the world that there has been tolerance in this respect, so it hasn't been considered automatically a breach of the obligation, so cases of non-compliance, even before the legislature has intervened with ad hoc measures. But when it comes to substantive failures, so failures to pay the tax due, then I think it's also important to consider that on top of the possible problems that taxpayers have been facing, which have been also in several cases connected with the protection of minimum vitale, also because people may have lost their jobs, there is still an obligation to contribute to fund the state revenue. And so from that perspective, it could be questioned whether there is in fact a situation of protection of fundamental rights on top of the rights of the collective interest to secure the funding. This is also important when it comes to the analysis of penalties and sanctions related to non-compliance, because if there is a case connected with procedures, then we'll have to look at it in a different way as to cases of non-compliance connected with the obligation to pay tax. But I would like to ask Philip now to share also his views of what we have learned from the 2020 related developments, also connected with what our national reporters have been producing within their works. Philip, so what are the points that in your view should be mentioned?
Well, there are a number of developments during 2020 that are covered in the report. Just to highlight one, which in a sense links back to the impact of COVID during the year, and that's been the whole question of confidentiality of taxpayer information. What we know as a consequence of COVID is that many more people have been working from home, including people working for tax authorities. And there's a much greater danger with individuals working from home using their personal computers that the information would be hacked from those computers. And so if tax authorities are to continue to function under COVID with staff working from home, it's particularly important that confidentiality is guaranteed. A number of developments during the year have highlighted the need for taxpayer confidentiality. Just to highlight one of them that's picked up in the report, very interesting case from South Africa during the course of the year, a litigation between the public protector in South Africa and SARS, the South African Revenue Service, where the public protector was seeking information in connection with a potential prosecution of Jacob Zuma the former president of South Africa in connection with tax fraud. SARS was asked by the public protector to provide information, and SARS said, no, this is tax information. We are not entitled to hand it over unless ordered to do so by a court. We can't just supply it in response to a request from the public protector, and the court in South Africa upheld that. Interesting example there of confidentiality of taxpayer information, but certainly that's something that has been thrown up particularly by the COVID year. Moving forward from there, we have additional matters to do with confidentiality. Is that something that you wanted to comment on, Pasquale?
Yes, Philip, I think it's quite important. If you look back at when we started this whole experience that has brought us to the Observatory on the Protection of Taxpayers' Rights, when we were drafting the IFA General Report, we noticed how strong the protection of confidentiality is in South Africa. And also we have outlined some which were considered to be at that time the best practices. And indeed, the fact that the judiciary has the possibility to intervene before tax authorities either access the domicile or release information, I think it's it's a matter of strict importance. It's nice to see over the years, and of course, we are very glad about this judgment from the High Court of South Africa, the Gauteng Division case 84074/19, as Philip indicated, SARS versus Public Protector and others, which is available on our general report. We're very glad also to see that over the years this has developed as a global trend. There have been judgments concerning the release of information held by tax authorities also in the European region in the past. So, if one of the goals of our observatory is to raise issues that can be globally important and that can establish global practices, so it's nice to put together this judgment with case law from the European Court of Justice on VAT, including the ISPAS case in the past. So that's a development that goes really in the right direction. Philip, I think it's also interesting to look at what has developed, talking about the European region and the European Court of Justice. It's also important to share with our audience the development concerning cross-border situations and exchange of information, because on the 6th of October 2020, there has been an important judgment which is officially known as the Luxembourg versus B and Luxembourg versus BCDFC, but it's also known as Berlioz 2, or also with the name of the taxpayer involved. And this judgment, which is joint cases C245/19 and C246/19, is a development on the case law concerning the right of the affected persons to request compliance with the rule of law involving the behavior of tax authorities. We have been familiar with the issues that arise in connection with cross-border mutual assistance, and the Berlioz judgment from the Court of Justice, the predecessor of this judgment, this Berlioz judgment had indicated that there is a right to, there is a legal standing for the affected persons, and in that case, the third party holder of information that has the legal standing to question that the cross-border mutual assistance was conducted in line with the rule of law. Now, this Berlioz 2 judgment has added further elements to this line of case law, so there has been a development which I should say partly goes in the right direction and partly misses an opportunity to further strengthen the protection of those rights. And that is possibly also because that has not been following the position held in the opinion by Advocate General Kokot. And the Berlioz 2 judgment, so the one that I am now commenting on, has basically stated that if a third party holds information that concerns a taxpayer, then precluding the right of this person from bringing an action against a decision of tax authorities to provide that information is essentially not in line with the protection of fundamental rights, and in particular Article 14 to 47 of the EU Charter on Fundamental Rights. However, it has not acknowledged the existence of a right for the affected person herself, in this case, to do the same. So in a way, that is potentially also taking into account that this person may have a right in her state of residence. But if we, Philip, look back at the standards that we have developed since 19 as what we consider the best practice, what we look at best practice is pretty much about preventing damages from happening rather than at giving opportunities once that has happened. So if there is indeed a cross-border exchange of information, then whatever can be done in the request state. So once the information has been exchanged, will operate on an ex post basis. And frankly speaking, one more reason for being a little bit concerned about this development, or the fact that it's a missed opportunity, is also that the taxpayer, so the affected person herself, doesn't have the opportunity to block this. And I think that this is something which should be read in the light of the rights of non-state actors under public international law. And if there should be a right to a remedy in order to protect somebody's legal sphere from anything that can adversely affect it, then this is a missed opportunity. But it's a step that goes in the right direction. And I think, Philip, it's important also to take the opportunity to say that what we are recording across the world in connection with taxpayers' rights protection is also related to a research project in which we are also involved. And also it is a project carried out within the tax committee of the International Law Association on the protection of taxpayers' rights, on which there will soon be a release of this first phase, which focuses on the protection of taxpayers' rights. But I would like also, Philip, to ask you whether you have some additional comments on these developments concerning this Berlioz II judgment and the direction in which the effective protection of rights and the right to secure and the right to legal standing in connection with the rule of law and exchange of information is concerned.
Well, I think we're very much at a developing stage in this area. We're looking both at issues relating to exchange of information on request, and of course the Berlioz cases concerned exchange on request, but also to developments in the field of automatic exchange of information, where there are cases that are pending, some of them before the European Court, which are going to raise issues of the procedural guarantees, the data protection for taxpayers in connection with automatic exchange. I mean, perhaps it's time for us to say a little bit about what may be coming up in the year ahead, because we've just released the 2020 report. After that report was finalized, so to speak, there were a number of interesting developments with regards to retroactive tax legislation, a judgment from Belgium very early in 2021, another judgment from the European Court of Human Rights in the Vegitex case, also the arbitration award in the Cairn case from India. So these are all matters that are going to be picked up in 2021, perhaps by way of sort of rounding off this little snippet of information about the report and this little sort of podcast. We can say something about the plans for 2021. 2021 will be the 5th year since the observatory was set up, and since we've had these regular reports. So Pasquale, what are the plans for the 2021 report? Perhaps you can say a little bit about that by way of rounding this off.
Yeah. I think after 5 years after we have started this whole adventure of the observatory, time has come to review the standards that we have established. So basically to have the opportunity to verify if what we considered best practice at the time that we drafted the IFA General Report of 2015 are still to be regarded as such. So in other words, to allow the Observatory on Protection of Taxpayers' Rights to have a flow of values and legal protection, and to strengthen the protection of taxpayers' rights to contribute to a fairer world and a fairer tax world. Of course, we are going to do that again in a non-judgmental way. The idea is that you and I, Philip, have also the opportunity to learn from what has happened throughout the world and consider whether some of the issues that we saw as being problematic in the past have meanwhile been addressed. After all, this is also what we really wanted, Philip, to steer the world to a stronger protection of taxpayers' rights, not by telling a country off, but rather by making available to everyone in the world what we consider as best practice and providing reliable information from a technical perspective, unbiased and independent. So 2021 will be a challenge for us, and we hope that people who follow our activities will also enjoy our next release. Thank you very much.
Very good indeed. Thanks very much indeed, Pasquale.